What is mitigation of damages? Have you ever wondered what happens when someone breaches a contract? One important concept to grasp is mitigation of damages. This principle plays a key role in both contract and tort law. It requires the injured party to take reasonable steps to minimize their losses. Sometimes, you might hear this referred to as the duty to mitigate or the doctrine of avoidable consequences. At its core, the idea is straightforward. If someone suffers harm due to another's wrongful act, they cannot just sit back and let their losses pile up. The law expects them to act as a reasonable person would in similar circumstances. If they fail to take reasonable steps to limit their damages, the court may reduce the amount of damages awarded. In contract law, when one party breaches an agreement, the other party must make reasonable efforts to mitigate their damages. For instance, if a company cancels a contract with a supplier before the goods are delivered, the supplier should try to sell those goods to another buyer. If they do not make this effort, they may not recover the full amount of damages from the breaching party. A classic example is when a contractor is hired to build a bridge. If the hiring party cancels the contract and tells the contractor to stop work, the contractor should stop immediately. If they continue working, they may not be able to claim damages for the extra work because they had a duty to stop and prevent further losses. This principle also applies in tort law. If someone is injured due to another's negligence, they must seek appropriate medical treatment and follow medical advice to aid their recovery. Not doing so could result in a reduction of the damages awarded. In landlord-tenant situations, if a tenant abandons a lease early, the landlord must make reasonable efforts to find a new tenant. The landlord cannot simply leave the property vacant and claim the full rent from the former tenant for the remaining lease term. Understanding the mitigation of damages doctrine is essential for bar exam preparation, especially in the contracts section. It is a common topic in multiple choice and essay questions. Knowing when and how the duty to mitigate applies can help you analyze hypotheticals and structure your answers effectively. Remember, the injured party must take reasonable steps to limit their losses. If they fail to mitigate, it can reduce the damages awarded. This principle is applicable in both contract and tort law. Practical examples include seeking alternative employment, re-renting property, or following medical advice. By grasping this concept, you will be better prepared to handle contract law questions on the bar exam and in your legal practice.